Hi everyone, welcome to ACCA Corporate and Business Law. Today we want to look at the first topic, which is the business, political and legal system. I do know that some are doing global, some they are also doing English, which is known as UK. Yes, but there's a slight difference between the English and the global. There are some of the topics that are not in global and some that are not in English. So here's the difference. When you are studying English, on this module, you find that there will be contracts. There's a slight difference. I can give an estimate of 20% of the syllabus is different. Here on English, you find contracts. Here on global, you find the international trade and the Sharia law. So, but 80% of the syllabus is the same. 80% of the syllabus is the same when you look at the global and the English. So let's start with the first topic, the business, political, and the legal systems. So here's the summary. What are you expected to know? Which is the types of law, economic systems, political, legal system of court, rules of statutory interpretation. So what you have to understand is the first thing, what is law? What is it? So when we're talking about law, we're talking about the enforceable body of rules that exist in a society. You understand? So these are enforceable body of rules that exist in a society. So in other words, we're saying everyone must follow the rules. You understand? So we do believe that it is the government that do set the laws. It is the government that set the laws. But there are some countries that believe in religion of Islam where they say the law is ordained by God. You understand? Is God-given. So we are going to look also at that, the Sharia law. Okay, let's start with this. The types of law. Types of law. On the types of law, what do we have? We have what is called the national and the international, the national and the international. We also have the criminal law and the civil law, the national and international. Now, about the national law, we are looking at the laws that applies in your country. You understand? So if you're a Zimbabwean, you look at the laws that apply in your country. Now, international, it will be covering so many countries, the law that apply internationally. You understand? And on international law, we do have what is called the private international law. We also what is known as the public international law. So we all know the public international law, guys. We do have there is human rights. We have treaties. We have war. So there are so many things that do apply. So that are made public. The public international law. You understand? So guys, we do have public international law. So it's public, the treaties, the war, the human rights, etc. Right? So there are laws that apply, but there are some laws that are specific to the country when it deals with other countries. You understand? There are some laws that are specific to your nation that applies when you deal with other countries. And it will be now known as the private international law. You understand? Right. But the national, they exist in the country. So, but I want you to understand that in the exam, you can be given a question and they say which of the following is true. So I want you to understand that when the national law and the international law conflict, which law will apply? It is the national law that will apply. When the national law conflict with the international law, you apply national. You apply where you come from. So the law that applies is the law that is followed in your nation. You understand? Yes, so that's what applies. Right. Now we also have, so since we believe that the law is, it is the government that that put the laws that should be put into that put the laws that should apply. So we do believe that the law is what they will be doing is for the greater good. You understand? So that the law, we call it positive law. So what is positive law? Positive law is the law that is imposed by the government. But don't ask me that what about negative law? We don't have negative law, it's only positive law. You understand? The law is positive law, it is imposed by the government. Now, criminal and civil law. Criminal law and civil law. Now, criminal law applies when one makes a crime. And what is a crime? A crime is a conduct that is prohibited by the law. So when you break a rule, criminal law applies. You understand? So now we do have different rules. For example, we all know that you should not steal. If you steal or if you commit fraud, you'll be sued. You understand? So we all know that you get sued or you pay fines. You understand? So what applies is the criminal law because you are breaking rules. So if you break the rules, we will apply the criminal law. Criminal law applies. But on the civil law now occurs when you do not break the law. Maybe there are individuals or maybe firms that might have conflicts. But no one did break any rule. So we'll be applying a civil law. You understand? Now, and on criminal law, there is a terminology that is used. We do have the prosecutor and the accused. So if we are saying this person is an accused, this person is being accused of something. If you are the accused and we do have the prosecutor, we'll be saying there is a person who committed a crime. There is a person who did break the rules. You understand? So these are applied on criminal law only. But you can't just sue someone. For example, like maybe someone is being accused that he committed a crime, and maybe the punishment or maybe the person will be sued. Maybe it might be 7 years in jail, it might be 5 years in jail. So they don't just sue you, then they say you are being accused 5 years in jail. You have to provide evidence, not just any evidence. The evidence that you should provide on criminal law, because guys, these are more serious issues that we are talking about. So the evidence that you should provide, we say you should provide evidence in the way that you should be able to prove the case beyond reasonable doubt. So you should provide what is known as the heavy burden of proof. Be able to provide heavy burden of proof. So you should prove your case beyond reasonable doubt. So guys, I want you to understand this. When people might have knowledge about someone, then they say this person shouldn't be trusted because this person is a thief. They would say that. So if the person is a thief, why can't you just go and report so that you'll be sued? The issue is you don't have evidence. You understand? But the person will be sued when you provide evidence. Like when someone is caught stealing. You understand? Maybe you have the evidence. Or maybe someone did break in, I don't know, maybe a certain place, but you do have evidence. Maybe you had the CCTV cameras. You understand? When you provide evidence to the extent that people will not doubt about that, you prove your case beyond reasonable doubt, then the person can be sued. So you have to provide enough evidence. That's what we consider on the criminal law. But on the civil law now, we are not saying people, they can just have conflicts. So the terminology that we now use on civil law is different. So we don't choose prosecutor and accused on the civil law. So there will be a person who will be claiming. So maybe, okay, let me give you this. The person who will be claiming maybe to be compensated is called the claimant. And we have the person who is being accused is called the defendant. The defendant. So these are the terminology that we use. Claimant and defendant applies when we are looking at the civil law. No one did break any rule, but maybe the claimant wants to be compensated for something. Maybe like, for example, there was an accident. Maybe there was an accident there, but two people are arguing. This one will be saying you are wrong. You are the one who was wrong. This one will be defending himself that I was not wrong. You understand? So now when they solve the case, no one is going to be sued because no one did break any rule. So what we are saying here is the claimant is the one who is claiming. The defendant will be defending himself. So what happens here is we are not saying this one should provide heavy burden of proof because this is not a crime. So we just need the balance of probability. So what is the probability that this person is right? What is the probability that what you are saying is not true? So we say the balance of what? Of probability. Yes. So that's it. I can give you an example. A single event can even give rise to criminal law and also civil law. A single event. And give you an example. Here's an example. So guys, let's imagine this. We're just saying a broken leg caused to a pedestrian by a drunken driver. A broken leg caused to a pedestrian by a drunken driver. So guys, I'm saying this statement, this shows that it will give rise to two things. Criminal law is going to apply, civil law is going to apply. So guys, why is civil law applying? Or why is criminal law applying? You can try to think. Why is civil law applying? Why is criminal law applying? So we were saying a broken leg caused to a pedestrian by a drunken driver is going to give. So guys, in life you can make a mistake. Like a broken leg caused to a pedestrian. There was a pedestrian, but there was an accident. If you're a driver, you won't be sued for that. These are mistakes. You understand? So what you have to do if you are wrong, so the police won't sue you for that. Because accidents, they do okay, guys. So what they do is, what you should do if you are wrong, you just need to compensate the pedestrian. You understand? Like to pay hospital bills. So you won't be sued. So in other words, are you seeing that this is civil law? But guys, the problem is the driver was drunk. That's the problem. So that's why criminal law is applying. If the driver was not drunk, civil law we are going to apply civil law only. So we are saying a broken leg caused to a pedestrian. The pedestrian can claim for damages. So can claim to be compensated. So therefore, the pedestrian versus the driver, we are focusing on the civil law. But if you see the police are suing the driver, they are not suing because of what has happened to the pedestrian, but they are suing the driver because he has broken the law. So because he was drinking and driving, so that's criminal law. Easy peasy. Right. So that's it on the types of law. Right. Now we do have economic systems. So guys, on economic systems, we have planned, we have mixed in, we have planned, we have market, we have mixed economy. So if it's planned economy, what are we saying? Planned economy, we are saying the distribution of resources is determined by the government. You understand? So the planned economy, we are looking at the government. We are looking at the government, the distribution, the allocation of resources. So it is the government that do determine that. But on market economy now, we are now saying these are the market forces. So the supply and demand, on the supply and demand, it is not the government that is contributing to that, but it is the market force. So what is occurring in the market? So what are people demanding in the market? So but on the mix now, this is a combination of both. So the market forces and the government, right? So that's it. Then we also have the political systems. On the political systems now, we do have the legislator, we do have the executive, we do have the judiciary. Right. So guys, legislator, I'm sure you guys know about legislation. We will be talking about the laws, right? You know the legislation, we are talking about the laws. So what they do in the exam, they'll ask you a question: which board enacts the law, which board makes the laws, which board amends the laws. So about making of laws and amending of laws, it is, we just think about that. Making of law, enacting the law, amending the law. Guys, what are we talking about? We are talking about legislation. So it is the legislator. Do you get this? Right. So that's it. So the board that enacts, the board that makes, the board that repeals the law, the board that amends the law, it is the legislator. You understand? You just think of legislation. So it is the legislator. Right. Now the executive now the executive, this is now the government board. This is the government board. What do they do? Now this board, they do not make the law. So people, they think that it is the government that make laws. No. The legislator, it is the legislator that make the laws. But now the government board, now what they do, the executive, they now make a decision of what laws should be put into action. We are now talking about putting those laws that have been made by the legislator into action. So it is the government board or the executive that now decides the laws that should be put into action. Not that they are making laws, no, they are not making, but they are deciding of what laws should be put into action. But guys, you need to understand about laws. Guys, we are accountants. So we need to understand from the lawyers. So guys, they do have section number what, section number what. So guys, what is the role of the judiciary? Judiciary, just think of the judges. Just think of the judges, you understand? So the judiciary, what they do, they interpret those laws. Yes, so that's it. And on political systems, they will ask you a question that in UK, which board, in UK, they'll say the head of state is called what? Head of state. Guys, in UK, head of state, head of state is called what? Is called monarch. You understand? What about the head of executive? Head of executive is known as what? The prime minister. So you must know this because it's examined, right? Okay, let's move on. Let's move on to the legal systems. Let's move on to the legal systems. Now, on the legal systems, guys, we have common law and equity. Common law and equity. We also have the Sharia law. Right. Common law and equity. Guys, we know common law. Remember what I said? I said law is the enforceable body of rules that exist in a society. We all know about law. So guys, we all know, guys, that it's not a good thing to steal. We all know that it's not a good thing to commit fraud, right? So, but how do you know that? Is it because you were used to seeing posts or statements written that do not steal? Guys, have you ever seen where people they write statements that do not steal, or I don't know? Have you ever seen where maybe it might be companies, or it might be, or where you come from, or from your home, where have you ever seen even a billboard where they say do not steal, even a government saying do not steal? Guys, a law does not need to be written for us to say we have a law. But we are saying these are just board of rules that we know. We all know that this is not a good thing to do, this is the right thing to do. That we know in a society, you understand? So it does not need to be written for it to apply. So, okay, common law and equity. So now, the law does not become irrelevant just because it is old. Just think when you were born. Guys, when you were born, you grew up knowing that it's not a good thing to steal. You grew up knowing that you should not kill. You understand? So this shows that the law does not become irrelevant because it is old. You understand? That's common law. But now, equity was introduced. And what does it mean, equity? Equity, we are now talking about fairness. So like when they solve cases, fairness should be considered. You understand? So fairness, that's equity. So what we do, or what they do not change the law because it is old. But what they can do, they can add. So they introduced equity so that there will be fairness when solving cases. There have to be fairness. You understand? So we say equity was able to produce so better remedies and better procedures on solving the issues. And there were some achievements, and there are also 4 things that are highly examined. There is what is called specific performance, and there is what is called injunction. There is what is also known as rectification, and there is what is also known as precision. Right, these are 4 things that were introduced. So guys, we might have the claimant and the defendant. Remember what I've said on civil law. Right, so guys, this is what you have to understand. When cases are solved, this is what we expect after. Like number 1, there has to be specific performance, like the defendant, like let's say the defendant is the one who was wrong, you understand? What do we mean on specific performance? On the defendant will be saying, he must agree to do what he must do what he has agreed to do. You understand? The defendant must do what he has agreed to do. Imagine you were wrong and you have accepted that you are the one who was wrong, and yes, you have said that, yes, I'll compensate this person, I'll pay $50. You must do what you have agreed to do, that specific performance. Then what about injunction? Injunction, we are saying you must abstain from wrongdoing. The defendant must abstain from wrongdoing. That's an injunction. Then rectification. So guys, there will be documents. So we say alteration of the documents to reflect the pre-conduct status quo. So guys, we are saying, okay, we are saying on rectification, there's a difference between rectification and rescission. Rectification is about alteration of the documents, right? Right. To reflect the party's true intention. Yes, sir. Rectification, alteration of the documents to reflect the party's true intention. Then the rescission, now that's rescission will be saying what? If you're wrong, if you want to restore. So this is now restoration. You are restoring. So this is restoration. So you have to restore like the way things were before. You understand? So restoration, or we say you restore the things they were before, maybe before they were damaged. You understand? So this is called restoration of the pre-contact status quo, or the way things are. Right, so that's it. So that's common law and equity. Then guys, we also have the Sharia law. So there are those that believe in the religion of Islam, those that say law is God-given. It is so they do believe that it was Prophet Muhammad who was given law by God. So they do believe that it is God-given. And there are few countries that do believe in the religion of Islam, such as Iran. We do have Iran, we do have Iraq, we do have Pakistan. So those are some of the countries. So they follow Sharia law. So what they say we do have the main sources of law, of Sharia law. So the main sources, if they ask you in the exam, what are the main sources of Sharia law? We do have the Quran and the Sunnah. Those are the main, or we say those are the primary source of Sharia law. Then what about the secondary now? The secondary, they are known as what? The secondary, they are known as madhab. The secondary, they are known as madhab. Right. The secondary, they are known as madhab. But the main or the primary, main is the same thing as primary. We say it with the Quran and the Sunnah. Right. So guys, this is what you have to understand. After the death of Prophet Muhammad, so there were some schools that were developed. And there are some that believed that more interpretation is needed. So there are people that believe that the laws that they follow should be interpreted. So they say that they should be interpreted. So this is what they say through the techniques of taqlid. They said, it's hard here, it's hard. So they say those that believe that the laws should be interpreted, they follow it hard. But there are those that believe that no more interpretation is needed. So they follow the techniques of what? Taqlid. They follow the techniques of taqlid. So when you're answering multiple choice in the exam, if they say something about the Quran, Sunnah, Madhab, just know that taqlid is on its own. Because it's for those that believed that laws should not be interpreted, right? So that's it on Sharia law. And also we have what is known as the riba. They say riba, this is the interest. So they don't believe in charging interest. So if you charge interest, imagine someone, you borrow money. So if you lend someone money, you are not allowed to charge interest. So the idea is they believe that it's unfair to the borrower, number one. Number two, it's unfair to the economy, because they believe that it causes unfair distribution of resources. So I don't want to talk much on RIB on interest. We'll talk more on that when you are doing financial management. Right, so RIBA, they say this is interest which is forbidden. So in other words, on RIBA, we are saying it's an unlawful gain. Unlawful gain. Yeah, this is why they say it's unfair. It causes unfairness in the distribution of resources, because those that have more money are the ones who end up getting loans. Those that can't pay more interest, they can't get money. You understand? So they say interest is not good, so it's unlawful gain. So that's it. Right? Systems of courts. Systems of courts. So, okay, guys. Okay, we're done with this. Done with the legal systems. We also have rules of statutory interpretation. Rules of statutory interpretation. We have the literal rule, we have the golden rule. So literal rule, we say words they are given the ordinary dictionary meaning. So you are judged based on what you have said. But golden rule applies when we say, when what you have said, it is more than one meaning, so we apply golden rule. Right, now the systems of courts now, we have the civil court structure, we have the criminal court structure. So guys, in the exam, we've asked the question. They'll ask you which is the lowest court, which of the following is the lowest court. So just know that the magistrate court is the lowest court. So we do have the magistrate court is the lowest. If they say which is the highest court in Europe, we say what? ECJ is the highest court, European Court of Justice. You understand? So now, if they ask you a question, which of the following, so let me show you the structure. Let me show you the structure. So guys, we do have magistrate. We do have the crown. We do have the high court. We do have the court of appeal. We do have the supreme. Are you seeing the supreme is the highest? We have supreme, we have ECJ, European Court of Justice, European Court of Human Rights. Are you seeing this? So guys, are you seeing the structure? So there is also what is also called the county court. I'll talk about that. Right. And we also have what is employment. Yes, so maybe you are at work. There can be conflicts between the employee and the employer. So employment also applies. You follow. There is also you also follow the same up to Court of Appeal, Court to the Supreme Court. So yes, you can get injured at work as an employee. So what does law say? Law says the employer has the responsibility, right, to compensate you for that, right? So guys, but as in maybe the employer, the employer can refuse, right? But here is the issue. But if you were negligent, yes, you won't get compensated for the damages or for the injury, right? So law, we will talk more on the contracts on the UK. Right, so we have employment. So guys, this is the structure. If they say, if you are given a question in the exam, they will say, where do we solve minor offenses? Minor guys, if it's minor, it's magistrate. Minor offenses, they are solved on the magistrate court. They will say, what about the serious offenses? Obviously, in what? Crown court. So serious offenses, they are solved on Crown Court. But there's a terminology they use. They'll say indictable offenses are solved where indictable means more serious. So it is the Crown Court that solve those offenses, right? But what you have to understand is there are some situations whereby if the magistrates have some difficulties, they'll pass it to the court that is above. If the above court you have difficulties, pass it to the higher court. You understand? If higher court you have challenges, it will pass it to Court of Appeal. If Court of Appeal you have challenges, they will pass it to the Supreme Court. Are you seeing the rank? So in other words, the terminology that we use is, like we say, the Crown Court. Okay, or let me just start from High Court. I will say, is it making sense to you if I say the High Court will hear appeal of the lower courts? You understand? We can't say the magistrate court will hear appeal from the High Court. No. The High Court will hear appeal from the lower court. What about, let's compare the High Court and the Court of Appeal. It is the Court of Appeal that hear appeal from the High Court. Then they solve the issue. Because like when they have challenges the High Court, they will pass it to the Court of Appeal. So what the Court of Appeal will do, it will then hear the appeal of that court that is below, which is the High Court. They hear appeal. So we apply what is known as precedent. Precedent now is a previous court decision which another court is bound to follow, provided that there are no material differences. So when they have challenges, the Court of Appeal will hear appeal. So it makes sense for you to say the High Court can't hear appeal of this, or the Court of Appeal can't hear appeal of the Supreme. Now when this one have challenges, it is the Supreme Court that will pick it from there. So what's correct to say is, we'll say the Supreme Court will hear appeal of the Court of Appeal. You understand? So that's it. So guys, now the High Court, we have, on the High Court, we have what is known as, on the High Court, there are 3 divisions. So we do have the family, we do have the family division, we do have what is called the QBD and the Chancery. The family division, the Queen's Bench division, the Chancery division. They're asking the exam that where do we solve matrimonial issues? Guys, matrimonial issues, we are talking about marriages. Where do we solve? It's family. So on the multiple choice, you pick family division under High Court. If you are not given family division, or they'll say Magistrate, Crown, High Court, Court of Appeal, you just think of family division is under which court? It is under High Court. So the correct answer will be High Court. You understand? So in family, we solve matrimonial issues. You understand? If they say the highest court in Europe is ECJ, you understand? Right. Then this structure is the same with criminal and the civil. But there is court that is only found in civil. So which is the county court? It's only on civil court structure. The county court is only found in civil court structure. On the criminal court structure, we don't have county court. If I remove this, this is criminal, but if I add this, it will be now civil court structure. If I remove county, it will be criminal court structure. If I add it, it will be civil court structure. You follow, right? So that's it, guys. Those are the system of courts. So we are done with the first chapter. Thank you very much for your time.